Hi, my name is Kaisa Krusko, and I am a family law attorney in Bedford, New Hampshire. Property division in New Hampshire divorces is guided by RSA 458-16A. All property owned by either party, either individually or jointly, is put into the pool and called marital property that is going to be subject to division in the divorce. This means, for example, if the house is titled in one party's name and not the other's, it doesn't matter. It's still property that will be divided by the court. The court is tasked with the job of dividing property equitably. Equitably does not mean equally, however. There is a presumption under the law that an equal division of the property will be equitable, but this is a rebuttable presumption. In other words, you can bring to the court factors that the court should consider as to why an equal property division is not equitable, and the court should divide the property in a different fashion. There are factors that are enumerated in RSA 458-16A that you should be familiar with. These are the factors that the court will rely on in coming to an equitable division of the property. These factors include such things as the length of the marriage, the ability of each party to acquire assets in the future, the ability of the custodial parent to engage in gainful employment while caring for the children, the need of the custodial parent to occupy the marital home or use other household effects, the actions of either party in the marriage that contributed to the growth or the diminution of assets, the fault of either party in the breakdown of the marriage. A significant disparity between the parties and their contributions to the marriage can also be a factor for the court to consider. This can include each party's contribution to the care of the children, not just economic factors. The contribution that one spouse has made to the other spouse for education, the tax consequences of any order that the court is going to make can also be a factor. Tax deductions for the children, or tax consequences of alimony, or other issues such as that. Inheritance that either party has received can also be a factor that the court can consider. And then the court also has a catch-all phrase that allows the court to consider any other factor not already enumerated. This could be something such as the length of the party's relationship prior to the divorce or the marriage. If there was a significant length of time the parties cohabitated, was together as a family before they got married, that's something that the court may want to consider in dividing the property. Thank you for listening, and if you have any questions, please feel free to contact me at my office, by telephone, or email, or through my website.